Start. It is general judicial experience that in matters of law involving questions of construing statutory or constitutional provisions, two views are often reasonably possible, and when judicial approach has to make a choice between the two reasonably possible views, the process of decision making is often very difficult and delicate. Stop. When Supreme Court hears appeals against decision of high courts and is required to consider that propriety or correctness of view taken by the high courts on any law, it would be open to Supreme Court to hold that though the view taken by the High Court is reasonably possible, the alternative view, which is also reasonably possible, is better and should be preferred. Stop. In such a case, the choice is between the view taken by the High Courts, whose judgment is under appeal, and alternative view which appears to this court to be more reasonable, and in accepting its own view in preference to that of the High Court, Supreme Court would be discharging its duty as court of appeal. Stop. It is just not dominating as the apex court, but it only decides a case on question of law, and when it decides a case under question of law, its decisions are under Article 141 binding on all courts within the territory of India, and so it must be the constant endeavour and concern of Supreme Court to introduce and maintain an element of certainty and continuity in the interpretation of law in the country. Stop. Para. Especially when a matter of bail applications comes, it is only the magistrate or sessions court or high court in which power is imposed to grant it. Stop. But if the accused feels that even by apprehending to the high court his bail application is rejected on considering no grounds or non-perusal of grounds to be considered for granting bail to him, then in such a case the accused approaches the Honorable Supreme Court on pointing the High Court's decision, and Apex Court can reverse the decision of High Court, which will obviously become binding on all the courts in India. Stop. Para. The Honorable Supreme Court can review its own decision. Stop. If it is found by the Supreme Court that its previous decision is erroneous for the public good, the Honorable Court can review and change its own decisions. Stop. Thus, in this chapter, as the name itself reveals, the Supreme Court on law of bails, various decisions of Supreme Court are being discussed in the following on law relating to bails. Stop.